everybody. Like Deborah said, my name is Carl Christian Johannesson. I'm a staff attorney with the Minnesota Association of Townships, and I'll be, like Deborah said, again presenting on Contracting 101. When you do receive links to the materials, there will be two materials provided. One is just a outline of what we're going through. It's essentially the slides more in depth with some of the statutes involved and some of the more particular language. The other one is, and I'll address this more as we get into discussing the municipal contract law. The other is a checklist of issues that the town should consider when looking at these at their contracting. So the first thing I want to look at, just our general outline for the next hour or so, are just contracting basics. What is an offer, acceptance, and consideration, and other issues that you should be aware of when dealing with contracts. A short portion on just general contracting restrictions for the town, which is, again, the municipal contract law, and conflicts of interest are the main two we'll focus on. And then we'll talk about the municipal contract law, which is really the procedure that townships have to follow when they want to contract. Like I said, I want to look at contracting basics here. So first and foremost, Minnesota law provides a means for townships to contract. Minnesota statute 365.02 says a town may enter into any contract that is necessary for the town to use its powers, meaning that if a town needs a contract to use its powers, for instance, if they need a snow plowing contract to make sure that the roads are safe during winter, they can contract to do the snow plowing. If they have to build a town hall, the town can contract with a builder or a contractor to build the town hall. If the town needs a planning and zoning administrator, they can create an employment contract with that administrator so that they can assist the town in conducting their planning and zoning. I also brought up point 4 here of the statute, or the sub 4 of the statute. It says dispose of, control, and use town property as its residents consider expedient. Just in general, this allows the town to use its property, real or personal, meaning they can use their real estate or other personal property to be able to contract. So generally, what is a contract? And without getting too far into the legal weeds here, you have 3 major pieces. You have your offer, your acceptance, and your valuable consideration. On the outline, it lists the restatement definition, but maybe something a little bit simpler than that is, I'll give you something if you give me something. That is an offer. An acceptance, again, I have the restatement's definition, or you can also look at it as a mutual agreement by the terms given of the offer, or I agree to your terms. That's an acceptance to that offer. Now, the more important point is valuable consideration. What does that mean? Again, I have the restatement's definition, which is just a legal treatise on how a group of people want the law to be understood. But in general, the valuable consideration is the thing part of the offer. I'll give you something if you give me something. That something is going to be that valuable consideration. It's not just about being considerate to the other person. It's not being nice or making sure that they have a part. It's really a valuable exchange of goods, which can include money, labor, an exchange of things. So you can trade a plow truck for a road grader, a change in legal relationship. Think like a stay of a lawsuit or a settlement before trial. Again, that's going to that stay of a lawsuit, that settlement, you're changing the legal definitions or legal interests of things. Employment, modification of an actual contract is considered a consideration, or a change of familial status. Again, that's also consideration. One other note, these do not have to be of similar common value. Instead, consideration can be as little as, this is often the term used in your first year contracting course, as little as a peppercorn. I can give you, if you give me $1,000, I can give you a peppercorn, and that's an exchange that has valuable consideration from both parties. Once an exchange of consideration has occurred by at least one party, the other party will need to fulfill their contract or risk a contractual breach. One other note I do want to make here, it's not within the outline, but it is here on the slides. Should a contract be written? Well, there are certain things that it's required that a contract is written for. This is property sales, sales of goods, or things that can be moved. Think of anything you would buy from like a grocery store or general store. Any sales of that over $500 needs to be written. A contract that cannot be completed within a year. So if there's a provision within the contract that it'll go for 18 months, that contract must be written. Suretyships, so types of insurances, need to be written. And then consideration of marriage. A marriage contract does have to actually be written. It can't be a vocal exchange. What should contracts be, or what type of contract should be written? Well, really just about anything. I remember one attorney saying anything larger than a gopher bounty should have a written contract. And that's very true here as well. We should be looking to have written contracts. It helps show the town's position at any time. It helps the town have good records. A written contract is helpful, even when it's not necessarily required by law. Just common town contracts. If we look at these things, the town contracts for just about everything. Any action that the town is going to do, a town will probably have to contract for. So this includes joint powers agreements, professional services, construction or maintenance services, employment, real estate, personal property, bidding goods, development agreements, and the list keeps going on. So when a town is making an agreement with somebody, just remember that it probably falls under one of these contract issues. So the town is going to have to follow the different restrictions or the different guidelines or the different processes that we'll talk about later. Contracting restrictions. Generally, there are two big categories of restrictions for townships. The first is the municipal contract law. The municipal contract law is a set, really comes down to this three contracting levels. The $0 to $25,000, $25,000 to $175,000, and $175,000 plus, that has these either direct negotiation to quote requirement or the sealed bidding process requirement. Based upon the size of the contract, really the purpose is to create a uniform contracting process for government entities so that contractors can work with their township, and they can also work with a state agency and be sure that they have the same process when going through it. It also protects public funds, making sure that the town or any government entity is getting the best price, and then it continues to reduce fraud and abuse from public officials. What does it apply to? Well, it doesn't apply to every contract, but it does apply to both the sale and the purchase of. So if the town is selling any supplies, materials, or equipment, it would apply to that. If the town is purchasing any of that, it would apply. So supplies, materials, equipment, rentals, or as it doesn't apply to purchasing real estate, because if you're looking to purchase land for a town hall, It's not that people are going to be sending you bids. You can purchase that town hall on the property you're looking for, but of any construction, alteration, repair, maintenance on that land to any of that property, the municipal contract law applies there as well. The other big restriction is conflict of interest, and we're not going to get into conflict of interest today, but it applies whenever a public officer has the authority to make it any sale, lease, or contract in their official capacity that cannot be, and they cannot benefit financially from it, which means that anybody within their household would receive property or money, or there would be an exchange of property or money in that process. It doesn't mean that you're on the winning side, that you're gaining money. If you're losing money, or someone in your household is losing money, you have to follow certain rules. Again, this is really to help protect public funds and reduce the potential for fraud or abuse by public officials. As for penalties, if you don't follow either of these laws, the municipal contract law can have the contract voided, meaning that you lose the contract, and you can also pay damages to those who are preparing their unsuccessful bids. So if you don't follow the MCL, your original contract can be voided, and you can be required to pay damages for the unsuccessful bid. That's not damages for the entire contract that was lost. That's just the money that was lost in preparing the bid. For a conflict of interest, if you're a participating officer, meaning that really only applies to supervisors, there would be a gross misdemeanor involved for each officer who participates, each officer who votes, as well as a doctrine known as ultra vires or ultra vires will apply, meaning that you were above your authority, which then leads to the contract being voided in that sense because you weren't legally allowed to contract. So now that we're done with that preliminary discussion, we'll get into really the meat of what we're looking at today. Again, why are we looking at the municipal contract law so in-depthly? Because this is really about making sure that the town follows the proper procedures needed when the town is looking to make a contract. We'll look at a couple of things, 4 main things here. So we'll look at estimating the actual value of the contract. How can we figure out which of the 3 levels the applies in that case? Then we'll look at the 3 levels specifically. The sealed bidding process is has numerous steps, and so I want to look at each of those steps individually as well, discuss some of the intricacies involved, and how you can hope to minimize some of the difficulties there. And then because the sealed bidding process it is so in-depth, there are alternatives to it, and the town should be aware of those when contracting, and in some cases must actually be aware of those. So first, let's discuss estimating the price. The first thing we have to do is figure out how much the town is either looking to spend or to sell their good for. So you can use, if there's a price tag and those price tags are consistent, so say you're buying a new truck or a new to you truck, a used truck. If you're looking for a specific brand truck, because that's the one that either your supervisors or your town employee is most used to using, the general value of that truck can be easily estimated by price tags. If you are looking to sell some equipment, so if you're looking to sell a used truck, you can use Kelley Blue Book. If you have other services or similar value estimation services, I mean, there are services that range from purchasing bicycles all the way to musical equipment and other electronic tools to assist in that all give value estimations that will show that the town is doing its due diligence, making sure that the proper estimate is there. If the town is still struggling after using those tools, you can certainly reach out to other municipalities, seeing how much they paid for similar processes. So if you're looking to rebuild a road, for instance, and you know that the next township over recently rebuilt a road, you can ask them at, say, similar distance, or at least has portions that are very similar to the current road that you're looking at. You could reach out to the other township, see how much they had to spend. And then based upon that, you can create your value estimation. Rather than looking at value estimation tools, you can look at online options or other actions and see what's the general price that has been expended for that procedure. You can also reach out to industry professionals, and they will give you estimates over how much something may cost or how much something may sell for. That'll be helpful. When you're doing your value estimation, please also to make sure that you include the sales tax, just to make sure that you're within the proper range. Overestimating will tend to benefit the township because there's no penalty for using one of the higher processes, such as seeking 2 quotes or going through the sealed bidding process, when in fact the total contract cost less than what was anticipated. The other issue is trade-in value. The way that Minnesota law treats trade-in value is that the value will be it's understood as partial payment or part of the payment. It's not that the price is reduced of the contract that you're seeking. So say you're trading in a used truck for a new truck, that trade-in is seen as part of the purchase price, or it's seen as part of the purchase. It's exchanging goods plus money to receive a different good, rather than something else. So it doesn't reduce the overall contract price, it's just seen as payment of that. The other thing I want to look at here is splitting the contract. You can split a contract into what are known as reasonably divisible pieces. What are reasonably divisible pieces? Well, that's the question. So for instance, if you're building a new town hall, the framing and the plumbing, even if they're done by the same contractor, are reasonably divisible pieces. You can certainly have one person do the framing and one person do the plumbing. That's a reasonably divisible piece. It wouldn't be reasonably divisible to have one contractor build the wall or build one section of the wall and another build another section of the wall. So that wouldn't be reasonably divisible. You can't have one lay one section and the other lay another section. It would have to be a different process. Now the question comes to, what about roads? Can you split a reasonably divisible amount of road, or is the entire road just one? And so that depends on what the town, or how much of the road the town is doing at a time. So for instance, if the town plans to tar an entire section of road or rebuild an entire section, about a mile section of road over the course of the year, it's unlikely that if the purpose is being done over the course of the year, and the goal is to do it over the course of the year, that you can split that into quarter-mile chunks. However, if you're doing one section and then the town finds that they have enough funds to do another section, that might be a reasonably divisible piece. But when you're doing that, the town should be working with a town attorney or reaching out to Matt to see if there's any question about that being a reasonably divisible piece. So now that we have worked through that estimation, let's look back at each of the 3 contracting levels. So the first is direct negotiation. This is utilized for any contract that either isn't covered by the MCL, as we saw before. Real estate contracts, employment contracts aren't covered by the MCL, but any contract that is covered, it must be less than $25,000. Now, these levels do get commonly increased by the legislature, so the town should be careful to just review every couple of years or so, or reach out to Matt every couple of years or so as to what the current MCL value is, or the MCL levels are. Now, in direct negotiation, what is the overall process here? And if you look at your checklist, it's very simple. It's offer, acceptance, and valuable consideration. It's just going back to those very basics of contracting. It should be in writing, but in general, other than the overall price, there aren't many restrictions here to direct negotiation. Now, the two quotes. This is another way to put this is two offers from two different people. This must be used for any contract between $25,000 and $175,000. And it's misunderstood in a couple of ways. The first thing I want to clear up is there are two different processes, and we should be clear when we're discussing them. You have receiving two quotes, and then the sealed bidding process. So quotes and bids under the MCL are treated differently. And so when you're advertising, you do want to make sure as you maintain the process that you're looking to have, because the quote process is simpler than the sealed bidding process. The town should be clear that they're seeking two quotes or seeking quotes rather than seeking sealed bids. Now, I'm also using another particular word, seek. The town doesn't have to receive two quotes. They have to seek two quotes. So if only one quote is found, the town should make note of that, either in the meeting minutes or by passing a resolution, that they could only find one quote. Now, this isn't to say try to limit the quotes as much as possible. Truly try to seek the best quote, because that'll best serve the township and your constituents. Now, any quote received, or if you have to make note that only one quote was received, that must be kept on file. So the clerk must keep that on file for at least 1 year. Now, which quotes can the town accept? Under the sealed bidding process, we'll see this later, that you're restricted to only one bidder. But for the quote, you can really accept any of the quotes. You should be very careful to accept the lowest, most conforming quote. Think of a cost-benefit analysis. Does this give me everything I need? And is it the cheapest? And that's probably the quote I should take. If otherwise, if it's either more expensive or it doesn't conform, or if it doesn't conform but less expensive, the town should look at the one that's conforming the most to achieve the town's goal or the town's project. So how do we find these quotes? I guess the town board could say at an open meeting that we are looking for quotes to contract to buy a new vehicle that's under $175,000. You can say that, but there's no certainty that you're going to receive any quotes for that, let alone one. So what should the town do in those situations when it's looking for someone to contract with? Should advertise it in newspapers, on websites. Maybe this is going a little bit above and beyond, but look at billboards or magazines. You can also do it with a notice at a town hall, or going back to the open board meeting, word of mouth. Ask the residents to find everyone they can to submit a quote so that the town can move on. Now we're at the big part here. We're going to start looking at the sealed bidding process. So this is used for any contract above $175,000 or any rental contract above $6,000. Any rental contract below that can be let through direct negotiation. That's one of those exceptions in the municipal contract law. Generally speaking, the purpose of this is to make sure that the town isn't manipulating the contracting process in some way for such a large contract, and that the town, town is finding the best priced contract for those who are willing to submit a contract. So the general process is about 5 steps, though it'll seem like it's much longer than that. The first is to create specifications, and it's to publish the advertisement of those specifications. Then after receiving all those the bids, the town will open them. Then after opening the bids, they will investigate the bids. And then after investigating the bids, the town will officially make its decision. There are also alternatives, such as requests for proposal, cooperative purchasing, intergovernmental purchasing, electronic purchases through reverse auctions, and we'll talk about those more later. Now, one thing I do want to make note of, the sealed bidding process is regarding any contract above $175,000. It would be very prudent for the town to consider hiring a town attorney in this process. It'll help make sure that the town is getting the contract it's seeking, help make sure that the town is getting the best value it can for the contract. And the attorney will be able to help draft, especially the specifications, and help in investigating the bid to make sure that everything is conforming to the town's needs and wants. So let's look at first the specifications. So they must first of all be specifically definitive. They can't be too vague. They can't say, oh, we're in the market to buy a snowplow. It can't be too vague to just say that we're looking for something. You should narrow down to what you want. So if you're looking to build a road with asphalt, you look at the certain weight load per square foot of asphalt. If you're looking to buy a snowplow, the certain size or certain range of plows on the snowplow. If you're building a town hall, a certain gauge of electrical wire installed in the new building, or a certain diameter of piping, or if you want the frame built in a certain way, you should be very clear as to that in your specifications. Any other specific requirements that the town is looking to have. If you want the black back slope on a road to be a certain degree, please make sure to add that in your specifications. However, it can't be too exclusive. You can't be so strict as to exclude all but one contract, except in very limited circumstances. These are referred to as non-competitive, either supplies or agreements. There are some supplies, there are some contracting that is only done by so few people or even one person that they are functionally non-competitive. It would be the town to generally, it is generally best to avoid to seek non-competitive agreements. But if you're going to, please work with your town attorney, because as we saw, if the town is found violating the MCL, it can void the contract and the town can be required to pay damages. Now, these specifications also have to include terms and conditions. Again, your town attorney will be familiar with these, and so it'd be best to work with them on including these. Some ideas of what should be included is the town's right to reject all bids. The town chooses to determine the most important award factors, the location and time of delivery for the bid, if and how the damages will be liquidated if there is any sort of damages that occur, any required maintenance that needs to go on, any warranties by either party that either party wants, who provides the training and use of equipment if there is equipment involved that requires specialized training, how conflicts will be resolved, who is the mediator. Oftentimes you'll look at some business contracts, they'll have a specific person in mind for the mediation, and that might be helpful here too. Specifics regarding acceptance, if there's a specific fashion in which the town expects to accept, the period of time when this may occur, and any other special conditions, again, at the town's desire. The towns can also ask, if their attorney is unclear on a certain situation, they ask for a vendor to assist. However, the vendor is should be either excluded or made sure that they don't have an unfair advantage in this process. If they're seeing the bid specifications early on, then the vendor will have an unfair advantage in this process because they're able to prepare it prior to anyone else. The next is pre-qualifications. Again, if you're going to have any pre-qualifications, please work with your town attorney to make sure that you aren't violating the MCL, because there is no specified procedure in Minnesota law. So a town attorney will understand. So what exactly is a pre-qualification? Well, since most towns must award the contract to the lowest responsible bidder, the town can seek to define what a responsible bidder is. And so this process is to provide the pre-qualification process to make sure that only responsible bidders are applying or bidding for the contract. The other note I want to make is that the town can have veterans preferences in contracting. Again, probably best to work with your town attorney in making sure that you're doing so in the proper manner. Once you have created your specifications, the town would then publish those specifications so that you can start applying, so that contractors can start applying. The town must publish the specifications in an official newspaper at least 10 days prior to the meeting where the bids will be open. Of course, this process can be longer, but it must be at least 10 days prior to the meeting where the bids will be opened. So if you have a meeting on, say, October 15th, the town must publish those requirements by October 5th at the latest. Any projects requiring special assessment may have increased requirements. Any project that is $175,000 to $350,000 may follow that 10-day publishing requirement. However, if it's above $350,000 and special assessments are involved, you must publish the specifications at least 3 weeks prior to opening the bid. There are also alternatives to publishing notice that can be on either the town's website or in trade journals. However, they must have a substantially similar format to the newspaper publication, must be published simultaneously with the meeting minutes, meaning that the meeting minutes must be involved to show that the town is publishing the advertisement and that this is the advertisement. And then for the first 6 months, the town must simultaneously publish the notice on the website or in the trade journal, along in the official newspaper with the meeting minutes showing that the town is looking to move their publishing to their website. So after discussing the overall advertisement process, let's just look at what the advertisement should include. Basically, a description of the product or a description of the service being sought or given, how to find the specifications, so how to reach the clerk to get the full bid specifications, the bid requirements. So this is the overall view of what the town is looking for. We're looking for someone to pave 1 mile of town road at this location. Specifics regarding that can be found with the town clerk. Where to submit the bids, the deadline to submit the bids. Again, remember, this has to be at least 10 days prior to the board meeting in which these bids are going to be open. The time and place for the opening of the bid, and the location where that's going to happen, the town officers who are going to be present at that opening, a statement indicating that there may be a delay in awarding the bid so that the town has time to investigate and then make a decision, and that the town has the right to reject all bids submitted. If there is a construction project, we do have to note that there are additional requirements that the town must follow in their publishing. The advertisement must state that if anyone does not meet the minimum criteria for an established in Minnesota law, this being Minnesota Statute 16C.285 Subdivision 3, or fails to comply with the verification requirements, that they aren't a responsible contractor and they cannot contract for a project or perform work on the project. Anyone who fails to comply with the verification requirements is declared a non-responsible contractor per Minnesota law. The advertisement shall also provide that any false statement under an oath verifying compliance with the minimum criteria shall make the contractor who made the false statements ineligible or not a responsible contractor, and the ineligibility may terminate the contract that was awarded to that person. The advertisements shall also state that a prime contractor, that is the primary contractor that's working with the township, shall include its verification of compliance with all of its first-tier subcontractors, meaning that the person that the town is contracting with, that the people under him have their names also provided to the township, and that it intends to retain work on the project. Next, I want to discuss opening the bid. Remember that these are sealed, so the bid has to remain unread or unopened by the decision makers until the time that the town has decided to open the bids and to start reviewing the bids. You can have a town clerk or an engineer open and review the bid prior to the meeting so that they can help explain some of the technical aspects so that the meeting isn't bogged down by all of these technical issues. The next part is that bids can be received electronically. You can receive bids through email. However, you do need to make sure that in the advertisement, you know who to email to and in what form. So if that's as just part of the message of the email, or if that's as an attachment onto the email, that you have that understanding. The town should also install policies on how the bid is to be opened and printed so that town board can review it come the meeting. A bid cannot be received by fax or by facsimile. It is unlikely that these would meet the definition of sealed because there is no way to prevent a decision maker from looking at it prior to the meeting. These bids do not come ever at any point unsealed. They're all at any point sealed because there is no way to make them confidential in some way. After the bid has been opened, the town board starts investigating the bid. The first thing you have to determine is the person, the lowest responsible bidder. The town has to make sure that that requirement applies in this case. What does the lowest, when does it apply? Well, the lowest responsible bidder applies to any purchase, meaning that if the town is not looking to either purchase a good or looking to contract out in order to pay someone to do work for the township, it doesn't apply. If the town is selling one of their vehicles, they do not have to find the lowest responsible bidder because then the town would be selling goods for $1. What does the lowest responsible bidder mean? It doesn't mean that the town has to find the cheapest bidder, but they must find the cheapest bidder who fulfills the contract. In other words, the cheapest bidder that is responsible. Again, lowest responsible bidder. What are some factors that the town can include? Well, this includes financial responsibility, integrity, skill, and the ability, including the likelihood of providing a faithful and satisfactory performance. How do we determine whether a bidder is the lowest responsible bidder? Well, we can reach out to other municipalities to see if they had a good working relationship with them, reviewing your own factors, doing some investigation yourself. You could reach out to other contractors who didn't submit bids to see if they have any knowledge of this bidder and whether they're responsible or not. After we have determined if someone is the lowest responsible bidder, then you have to determine whether their bid was accurate to the bid specifications. The town can accept non-material deviations, but can't accept material deviations. Generally speaking, a material deviation is any issue that gives the bidder a substantial advantage over the other bidders. If we again look at our outline, there are several examples here. I want to go through a couple of them. The first is a difference in the contract's payment date that was 4 months earlier than the date provided in the specifications. This would give the bidder the ability to either receive money or pay sooner, again, to benefit the bidder, making it seem more positive in the town's eyes. Though, again, not part of this, it runs against the specifications. The next is the stipulation stating that the equipment sold to the city be installed to the company's specifications instead of the city's. The deviation also included the failure to agree to pay for inspections during a 6-month trial period, and that was called for in the city's specifications. In other words, they're changing the specifications. The next is a modification that allowed a bidder to pay earlier and change the specifications to relieve the bidder from any completion penalty if the delayed performance was due to circumstances beyond the bidder's control. Again, benefiting the bidder unfairly. The next is a bidder's deviation by adding a 10% escalation clause, meaning that the bidder's price would change based upon other bidders' prices, thus giving that bidder an advantage. Submission of a single bid for an entire contract, and the specifications asked for 4 separate bids for the contract's 4 parts, raising the value of the contract, and by having it all in one, the bidder was probably able to make it cheaper overall, but that's not what the town was looking for. Allowing a bidder to increase its bid because of a mathematical error, a variation that affects the price, quality, or quantity or manner of performance, a failure to comply with specifications, and then deleting a plus sign from a defective bid so that it became, in fact, the lowest bid. All of these are giving that bidder a unfair and substantial advantage over the other bidders. So that's why those would be material deviations. What are some examples of immaterial deviations or non-material deviations? A failure to submit an affidavit, submission of a personal check rather than a certified check, failure to describe their status properly, failure to have their bid bond notarized, not actually sealing the bid, and then a few-minute delay in delivering the sealed bid. These are all issues that are non-material. They don't actually change whether the bidder has an advantage or not. It's just issues that have come up while the bidder was preparing for the bid. Next, I want to talk about some changes to contracts. In short, can the contract or the bid be changed? No. If the board wants to work with that bidder, or at least give that bidder an opportunity, they could reject all bids and then restart the sealed bidding process. But there is no guarantee that that contractor is going to be the lowest responsible bidder. However, a board has the ability to relieve a bid. In other words, if someone is the lowest responsible bidder, that is their offer, and if the board accepts that offer, they are bound to that. However, there are sometimes when a bid may be relieved due to an error, if that error was so obvious to the town that when the bid was read, or was so obvious to the town when the bid was read. To determine if a bidder may be relieved, the town must determine 4 main things. The mistake was so substantial that it would be unreasonable to suppose that the contractor would have submitted the bid. The mistake was not a product of gross negligence. The contractor gave prompt notice to the town, and the town's position did not change from relying on the bid. That the town did not suffer damages or other than the loss resulting from the bid mistake. If there are questions as to whether a bid can be relieved, the town should keep working with their town attorney and ask the contractor for all documentation as to why they should be relieved. There can also be other mistakes. So first of all, unilateral mistakes or mistakes by just one party, such as transposing numerals, forgetting to include the amount of work for performing segments, and other mathematical errors. The town can relieve those bids again if they fall into those 4 factors, and the town again should be working with their town attorney to make sure that that has happened. It can also be rescinded for an error in judgment, such as if the work was too difficult, if rather than digging through clay, the contractor didn't realize that they were having to dig through granite. The quality of materials required, if the town, if there were different specifications that the bidder didn't realize, you could relieve one for that. And then other just judgment factors that aren't necessarily clear when first submitting the bid, those can be relieved. If someone refuses to sign because of a material mistake, the town may either award the contract to the second lowest bidder, or they can just reject all bids and re-advertise. So when the town is making the decision, again, the town has to award the bid to the lowest responsible bidder or reject all the bids other than a few situations that we've discussed before in relief of the contract. If no bid exists, the town then may re-advertise. As for rejecting the bid, the town has the right to reject all bids. It doesn't need that phrase in its advertisement, but it should still use that phrase in the advertisement because the court can potentially compel a town to accept the bid if they're to some degree trying to hide the ball. And then also note that there may be delay in accepting the bids. This is a process. This will take time. It shouldn't necessarily happen on the same night that you open and start investigating the bids. You should do it afterwards. There are also alternatives to the sealed bid. For the 4 major ones I want to address here are RFPs, or requests for proposals, or best value contracting. There are a lot of ways to rephrase it, but it's a very similar process to the lowest responsible, or to the sealed bidding process. However, it does away with the lowest responsible bidder requirement, and instead you award the bid to the person that has the most or fills the most criteria points. It's not commonly used by towns or even cities. There are some counties that have used it, but again, it's still kind of uncommon. If you're going to do it, you would have to have someone hired or trained to do RFPs, then develop the performance criteria, then create the RFP. Again, limitations do exist here. The town can also do intergovernmental purchases. There is only a need to directly negotiate. And here it is assumed that the sealed bidding process has already been fulfilled. So the town can contract with another town, city, county, with the state, and directly negotiate in order to receive the good or service there. Again, the assumption there is that the MCL was already followed, so there's not a need to go through it again. As for cooperative purchasing, there's only a need to directly negotiate. These are goods already bought by another state entity. It's very similar to the intergovernmental purchase, but it's a form of joint powers agreement. These do have to be considered before procuring quotes or the sealed bidding process. So look for a cooperative purchasing venture, see what they have before going through either the 2 levels above $25,000, and make sure that you're looking at that prior to going into the seeking the quotes or the sealed bidding process. As for electronic auctions or electronic purchases through reverse auctions. The town, it's assumed that the town is going to find the lowest price because the town can purchase supplies, materials, and equipment of any price through the system. What it does is that vendors will compete to provide the requested product at the lowest selling price, following a very similar procedure that the sealed bidding process sets out to do. So why are these alternatives? Well, to some degree, it's either very similar to the MCL, that you're going to achieve the same goal, or that the goal was already achieved. In total, that was the sealed bidding process and other requirements of contracting and how towns can contract. If you do have any questions, you can certainly give them now, and I'd be happy to address a few of them while time remains.
Thank you, Carl Christian. So we will now open today's program up to questions and answers. You can submit your questions in writing by typing them into the QA pod. So we'll give just a few moments to see if we have any questions come through. Okay, it doesn't look like we have any questions. Do you have any closing remarks before I conclude the program?
Again, thank you for attending. If you do have any further questions, please reach out to the MAT attorneys. We'd be happy to work through them with you. I know that there's a lot of information here, and thank you for listening.
Thank you so much. This concludes our session. I would like to thank our speaker for his participation and thank all of our registrants who attended today's program. Certificates of attendance and evaluation forms will be emailed to live attendees within 24 hours, and we ask that you take a few moments to provide us with your evaluation of today's program. I invite you to visit your association website for a list of more upcoming programs and hope that you each have a wonderful day. Thank you.